Hello, and welcome to another edition of Coffee Talk with Immigration Attorney Brian D. Lerner. In this particular episode, we are going to talk about what happens when you lose at immigration court and you lose at the Board of Immigration Appeals. The question is, where do you go from there? Is it over? Are you going to be deported? Is there anything that you can do to try to still fight your case? And the answer is yes. There's what is known as a petition for review. And a petition for review is essentially an appeal to the Circuit Court of Appeals where you happen to be. Now, let's say that you're in California and you go to the immigration court, and let's just say you apply for asylum or cancellation of removal or whatever it is you happen to apply for, and you lose. You can then appeal that to the Board of Immigration Appeals, which that happens to be in Virginia. It doesn't matter if you're in New York, Puerto Rico, Kansas, or California. It all goes to the same place when it gets to the BIA. However, once the BIA makes a decision, you're still under the administrative ambit of the Department of Justice, and essentially they're not judges which have been appointed by the President of the United States. Okay, so the first time that you really get into a situation where you can get what's called judicial review, because you have federal judges that are going to be able to make your particular case and a decision on the case, it is at the time that you would lose at the Board of Immigration Appeals and get up there. Now, a lot of times you will know that you don't have a case, for example, that could win at immigration court. You don't have a case that could win at the BIA, Board of Immigration Appeals, and you know the first time you're going to have a real chance at success is in the Circuit Court of Appeals. So again, like if you're in California, it's the Ninth Circuit Court of Appeals, and they go all the way across the U.S. First Circuit through 11th Circuit, then there's in Washington, D.C., the D.C. Circuit. So those are the circuit courts that will go up for the petition for review at the time that it's ready. Now, why is it, for example, that you might have the best chance once you get up there? Well, a lot of times, especially after 1996, where IRA came along, and they had these immigration laws that were severely restrictive, that were very anti-immigrant, and in a lot of respects, were unconstitutional, were not fair. The only time you're really going to have an opportunity to fight the constitutionality of a particular statute or law, the vagueness of it, all the due process, all of the constitutionally based arguments, you can make them at the immigration court, you can make them at the BIA, but they're not going to be able to really do anything with it because they have the law in front of them and they have to go with what they have. However, once you get up to the Circuit Court of Appeals, they certainly have the power to interpret the constitutionality of those laws, and they can make it so that you can, for example, they can say, you know, provision B of this particular provision is unconstitutional, or it allows retroactive application of the law, which is unconstitutional, or it violates due process. And then, you know, they could definitely rule in your favor and remand the case back, stating that, you know, that particular statute doesn't abide by certain provisions and therefore can't be used, or you know, make some other statement in regards to that particular law. And in fact, this is how we fight the unfair immigration laws. Now, as you might know, immigration attorneys can't make law, the judges can't make law, Circuit Court of Appeal can't make law, and it's really only Congress. But when it comes right down to it, the reality is that if we fight hard enough on each little piece that we find to be unfair or unconstitutional, and it goes up to the Circuit Courts of Appeal, and ultimately, if that doesn't work, to the U.S. Supreme Court, and it's determined that that particular provision is not valid, or the interpretation of it is different than has been given by U.S. immigration, in the benefit of the immigrant, then essentially what we're doing is we are chipping away at the unfair laws, at the anti-immigrant laws, at the unconstitutional laws, piece by piece by piece. Since 1996, since the IRA came out, there have been several of the provisions which have either been clarified in the favor of immigrants, have been void under certain circumstances as being unconstitutional. And so, in effect, it is the immigration attorneys fighting that do help with laws, with making unfair laws disappear, basically. And it's not easy. There's a lot of times that will go up and that won't happen, but it's the only realistic way. So if you happen to get denial from the BIA, you've got 30 days in which to do at least the notice for the petition for review. And I would strongly suggest that if you're going to go and fight it, that you get someone who knows what they're doing, that you get an immigration attorney that knows all about the constitutional and due process issues, and that can do statutory construction and tear apart the little statutes in order to try to find a provision that will apply in your particular case so that you might have a realistic chance of winning. So for example, earlier I said, well, you could apply for asylum or cancellation of removal, and cancellation of removal itself is a discretionary decision. It specifically says that you cannot appeal discretionary decision. You can't do a petition for review. However, if you look into how the hearing might have gone, maybe the judge made a decision not based upon the facts, but abused the discretion and made the decision based upon some other factor other than that, or misinterpreted a fact and so forth. So there's ways, even if it's a pure discretionary decision, and even if the law specifically say you cannot do a petition for review on that particular item, there are ways to pull out facts and laws that apply to your case that may make it so that you are able to go forward and do the petition for review. Now, the petition for review, once it gets up there, there's not an automatic stay of deportation anymore. There is with the Board of Immigration Appeals, but with the petition for review, you do have to file a motion to stay the deportation while the petition for review is pending. Just so you know, let's just say it's, the motion for stay is denied and they deport you. The petition for review can still go forward, but obviously you would prefer to have the motion to stay the deportation done and granted so that you don't have to be deported. You should also do a motion to extend voluntary departure if in fact you got voluntary departure in the first place, because you don't want that to disappear or turn into a deportation order because you forgot to do the motion. So again, very important to extend that voluntary departure as well. Now, when they get the petition for review, there's going to be the filing of the opening brief, the response brief, the reply brief, and so forth. And then the judges have the opportunity or the option, if they want to hear oral argument, they'll call the attorneys in to do a 10-minute or so oral argument on each side, to not just to recap everything they've done, but to answer any particular issues that they have that they want to get the attorney's view. So that will happen, and then ultimately you'll get a decision. The decision might be published, it might be unpublished. If it's published, it then becomes precedence for anyone else with that particular issue. If it's unpublished, then of course it cannot be used as precedence. But if they come with the decision, it could either be a complete reversal of the BIA, it could be a complete dismissal, meaning they agree with everything, or it could be a partial dismissal, partial remand. There are several different ways that it could go. But in any event, what will happen is it will permit you to go either way in order to get that decision. And just so you know, even if they deny the petition for review, you can then do a petition for rehearing en banc, okay? And what that means is you send it to all the judges, circuit judges in that jurisdiction, saying, well, you believe that these 3 judges who heard your case decided wrong because of A, B, C, and then you get another shot at the apple. And then from there, you can actually do a writ of certiorari to the U.S. Supreme Court, which is incredibly difficult to both prepare and to get that granted. But sometimes you have to go all the way to the top in order to win. So you have to be prepared to fight your case if you're going to fight it. But the reality is, if you don't, a lot of times you're going to be deported for the rest of your life, torn away from your family, from everything that you know. So you need to fight it if you're going to fight it. And the timelines are very, very strict. You get it in 5 minutes late, it's too bad. They're going to send it back to you. Sorry, goodbye, have a good day. So again, make sure you get someone who really knows what they're doing, because petition for reviews are the way and the place to fight the unfair immigration laws. Okay, if you have any questions or like to get a consultation, please contact me and I'll be happy to do so. For your information, I am admitted to circuit courts all across the United States, 1st through 11th circuits. I've argued all over, in order to help clients from New York to Hawaii to California to New Mexico. So give me a call. I'll be happy to help. More on the coming videos.